Good afternoon. Welcome, everyone. It's a doubly auspicious day in the life of our law school today. It's a annual or semi-annual event, auspicious day when we have the Owen J. Roberts Memorial Lecture, and I'll say a few more words about Justice Roberts in a few minutes. It's also an auspicious day whenever Professor Dorothy Roberts gives a lecture. Today we combine those two and have the privilege of listening to Professor Roberts talk about her important work on abolition constitutionalism. This lecture, the Roberts Lecture, has been going for about 70 years here. It is our our highest honor in terms of kind of constitutional law leadership. We identify every year or most years leading Supreme Court justices, constitutional scholars from around the country and around the world. It is rare but not unprecedented to have a sitting Penn law professor give this lecture, and I'm really honored that Dorothy is going to speak with us today. Her work, as I'll say in a few words, her work on abolition constitutionalism is featured in the Harvard Law Review as their Supreme Court foreword, which is kind of that venerable journal's recognition, and I should emphasize it is a selected, invited writing by a scholar who is determined by the editors of the Harvard Law Review to be the leading constitutional law voice in the country that they want to feature in this platform. So, Dorothy, congratulations on that as well. So here's something that makes me both proud and motivated as a dean. Professor Roberts is the first Penn law professor in over 50 years to write the Harvard Law Foreword. Can anybody name the last one? There's a trivia question. Paul Mishkin. Well, okay, Professor Burbank. Yeah. All right. I won't ask if you were on the faculty then, but no. All right. Thank you. Thank you, Steve. Yes, Paul Mishkin. And the motivating is we're not going to wait another 50 years. Professor Roberts is leading the catalyzing to have more of this. But the Roberts Lecture, named for Owen Roberts, who a former dean of this law school and a Supreme Court justice for 15 years, from 1930 to 1945. Justice Roberts made the choice, which seems unthinkable today. He left the Supreme Court to be dean of this law school. I guess he wanted a more stressful, challenging job or something, but too quiet at the Supreme Court. No, but he was an eminent lawyer and involved in a number of important government investigations before he became on the court. On the court, he was often the kind of swing vote on important cases, cast one of the key votes to essentially save the Roosevelt's New Deal from invalidation under kind of a Lochnerian jurisprudence. He voted in favor of the government programs there. And as I had forgotten, but I taught in a class a month ago, he was one of the three justices, and apropos of tonight's discussion of racial injustice, he was one of the three justices who dissented from the court's infamous Korematsu decision. And he wrote in his dissent that Fred Korematsu was singled out because of his race and ancestry in ways that violated the Constitution. Dorothy Roberts is an eminent scholar of race, gender, and the law. She is the 14th Penn Integrates Knowledge professor and came to this law school and this university about 8 years ago. She has joint appointments in the law school, Africana Studies, Department of Sociology, and here she holds the inaugural Raymond Pace and Sadie Tanner Massell Alexander chair. Her work is path-breaking in law, healthcare, and the role that race plays and continues to play in our society. And her voice is one that helps us see clearly the legacy of 400 years of race discrimination, as well as invites a path forward for thinking differently as we move ahead on issues ranging from healthcare to family law to employment discrimination to the subject of today's talk, prisons, prison abolition, prison reform. So, Professor Roberts, we're honored to hear your words. Thank you.
Thank you, Ted, and thanks so much for inviting me to give this lecture. I'm so deeply honored by it. I have many people to thank. Dory Pavel and her team helped put this all together, and I really enjoyed working with you. Thanks so much. Also, I have to thank my wonderful team of research assistants who helped with the Harvard Forward, Maddie Gray and Bridget Lavender, Jim Thompson, I see over here. There's Bridget, right? Yes, there you are. And Anthony Sacco, and just the entire Penn community that's embraced me when I got here and has been so supportive. My students, my wonderful faculty colleagues, wonderful staff, and alumni as well. So thank you so much. In September 1998, the Critical Resistance Collective held an international conference and strategy session at University of California, Berkeley, and that gathered more than 3,500 activists, former prisoners, lawyers, and scholars over 3 days to, quote, address the alarming growth of the prison system, popularize the idea of the prison industrial complex, and make abolition a practical theory of change. Some activists mark that gathering as the launch of the prison abolition movement. Critical Resistance developed the concept of prison industrial complex to name the expanding apparatus of surveillance, policing, and incarceration in US governments that is increasingly employed to solve problems caused by social inequality and to stifle political resistance. That gathering has grown into a nationwide network of activists organizing to abolish the prison industrial complex and to build a society that has no need for prisons. Now, last year, when the editors of the Harvard Law Review asked me to write the Supreme Court forward, it was a no-brainer to say yes. That's an offer you don't refuse. But then I had to figure out what to write about and to identify what is the cutting-edge topic that would help to shape the field of constitutional law in the decades to come. And I discovered that there'd been no sustained analysis of the relationship between prison abolition and the Constitution. In fact, if anything, some prison abolitionists not only reject constitutional law as a basis for achieving prison abolition, but view it really as an enemy of the movement because it's always served to facilitate and legitimate state violence against Black and other marginalized people. And this oppositional approach is understandable, given that so much of Supreme Court constitutional jurisprudence has been downright anti-abolitionist. Yet the Constitution was interpreted by past freedom fighters as an abolitionist document. Many anti-slavery activists viewed the Constitution as the foundation for their arguments, or at least one important foundation for their arguments, and for developing an alternative reading that called for democracy and freedom. After the Civil War, that abolitionist movement inspired radical Republicans in Congress to amend the Constitution explicitly to end slavery and to extend citizenship to Black Americans. Tragically, by 1900, a campaign of white supremacist terror, laws, and policies had effectively nullified the Reconstruction Amendments and replaced abolition with Jim Crow as the constitutional regime. So given that history, I asked myself, might legal scholars help to revive the abolitionist values in the Reconstruction Constitution to support contemporary abolitionist claims? Can prison abolitionists strategically use an abolitionist reading of the Constitution to defend their radical vision and implement steps toward achieving it? Might prison abolitionists even craft a new abolition constitutionalism that serves as a charter for a society without prisons. In this lecture, I want to make the case for an abolition constitutionalism that incorporates the theorizing of prison abolitionists. Now, there are two paths this interrogation might take. One is resigned to the futility of using US constitutional law to dismantle the prison industrial complex. The other finds utility in applying abolitionist history and law and the logic of the Reconstruction amendments to today's political conditions in the service of prison abolition. Despite my own disgust with the perpetual defense of oppression in the name of constitutional principles, I chose the second path. I'm inspired by the possibility of an abolition constitutionalism emerging from the struggle to demolish prisons and to create a society where they're obsolete. So I'll analyze the potential for a new abolition constitutionalism as follows. First, I'll provide a summary of prison abolition theory. I can only touch on it, but I hope to give those of you who aren't familiar with it some idea of what prison abolitionists are aiming for and how they strategize. And I'll highlight its foundational tenets that engage specifically with slavery and its eradication. It's a broader concept than that, but for purposes of this lecture, I'm going to focus on those tenets that relate to slavery and slavery abolition in particular. Next, I'll consider whether the US Constitution is an abolitionist document. And then finally, I'll tie together these topics by exploring the relationship between prison abolition and the US Constitution. I hope to persuade you that we should consider abolitionist history, the history of the Reconstruction amendments in particular, as a usable past in order to mark a way toward a radical future. I believe the prison abolition movement can reinvigorate abolition constitutionalism and forge a new constitutionalism on the path to building a society without prisons. The United States stands out from all nations on earth for its reliance on caging human beings. In the last 40 years, the US incarcerated population exploded from 500,000 to more than 2 million. Federal and state governments lock up more people and at higher rates than do any other governments in the world, and more than they ever have in US history. Most people sentenced to prison in the United States are from politically marginalized groups, poor, Black, and brown. Not only are Black people 5 times as likely to be incarcerated as white people, but also the lifetime probability of incarceration for Black boys in 2001 was estimated to be 32%, almost a third, likely to become imprisoned at some point in their lives, compared to only 6% for white boys. The female incarceration rate has grown twice as quickly as the male incarceration rate over the past few decades, and Black women are twice as likely as white women to be behind bars. But carceral logic extends beyond prison walls. Even systems that ostensibly exist to serve people's needs, like the healthcare system, public schools, public housing, public assistance, and child welfare, increasingly exist to regulate marginalized people who rely on these systems, and then they resort to punishment for those who don't comply with their regulations. There's a school-to-prison pipeline, a welfare-to-prison pipeline, a foster care-to-prison pipeline, even a hospital-to-prison pipeline. Prison abolitionists seek to dismantle this entire carceral system and replace it with a radically different way of running society, one where caging people is unnecessary and unthinkable. I find especially useful 3 central tenets that are common to formulations of prison philosophy. First, today's carceral punishment system can be traced back to slavery and the racial capitalist regime it relied on and that sustained it. Second, the expanding carceral system functions to oppress Black and other politically marginalized people in order to maintain that regime. Third, we can imagine and build a more humane and democratic society that no longer relies on prisons to meet human needs and solve social problems. These tenets lead to the conclusion that the only way to transform a society from a slavery-based society to a free one is to abolish the prison industrial complex. Many prison abolitionists have found the roots of today's criminal punishment system in the institution of chattel slavery. Even before I thought of myself as a prison abolitionist, my analyses of current criminal justice issues always seemed to take me back to slavery. Whether I was interrogating racism in the prosecutions of Black women for pregnancy-related crimes, which I wrote about in my first book, Killing the Black Body, or the disproportionately high placement of Black children in foster care, which was the subject of my second book, Shattered Bonds, or the high rates of incarceration in Black neighborhoods, police torture of Black suspects, or gang loitering policing, to name a few topics I've written about. I always found it essential to understand these practices as originating in the enslavement of Black people. The pillars of the U.S. criminal punishment system, police, prisons, and the death penalty, all have roots in racialized chattel slavery. The first police forces in the United States were slave patrols. Enslaved people who worked on plantations and farms were under the immediate control and discipline of their enslavers, who often were aided by overseers. The overseer's job was to enforce enslaved workers' total subjugation to enslavers by violently reprimanding perceived disobedience and failures to meet back-breaking productivity quotas. If you didn't pick enough cotton, you were tortured by overseers. And if you had a high quota, you surpassed the quota, now your quota became that, and you had to surpass it, or you would be brutally punished. The status of enslaved Africans as the property of their white enslavers meant that white people viewed Black people as a perpetual threat to their property. A threat seen as so great it necessitated employing armed forces to maintain order. In the aftermath of emancipation, when slaveholders' human property was no longer protected by slave law, a new form of policing emerged. Like overseers and slave patrols, Jim Crow police and private citizens who abetted them used terror primarily to enforce racial subjugation, not to apprehend people culpable of crimes. Take, for example, the coercive interrogation techniques we call the third degree, that's still used by police today. Their roots are in the first stages of lynching, typically carried out with the participation or sanction of the police, extracting a confession by torturing the accused. Even after the civil rights movement, police torture of suspects continues to be a tolerated means of confirming the presumed criminality of Black people. From the 1970s to the 1990s, white police officers in Chicago engaged in systematic torture of Black suspects. Under the command of Lieutenant John Burge, police coerced dozens of confessions from suspects by beating them, burning them with radiators and cigarettes, putting guns in their mouths, placing plastic bags over their heads, and delivering electric shocks to their ears, noses, fingers, and genitals. Burge's reign of torture was well known and condoned by police officers, the state's attorney's office, judges, and doctors at Cook County Hospital. They all saw clear evidence of torture on the bodies of Black defendants, and they did nothing about it. Police served to control Black and other marginalized communities through everyday physical intimidation and by funneling those they arrest into jails, prisons, and detention centers. Discriminatory stop and frisk policies have all of a sudden become a political hot button when Bloomberg joined the election campaigning, but they're common. He wasn't the only one who instituted stop and frisk. Stop and frisk is common in police departments across the nation. Police normally treat residents in communities of color aggressively, shouting commands at them, cursing at them, throwing them to the ground, tasing them, beating them, and kicking them, and handcuffing even little children. In just the last 2 weeks, you may have seen videos circulating on Twitter or other social media of I had to tweet, these are 2 different 6-year-old Black girls, they're not the same, who were arrested in school for having a tantrum. One was held without her parents even notification, let alone consent, for 48 hours in a mental institution, a little 6-year-old girl. And another one carried screaming, please don't take me to jail, please don't take me to jail, let me stay in school, as the police officer handcuffed her and took her into the police car. For young men of color, police use of force is among the leading causes of death. Black women, women of color, and queer women are especially vulnerable to sexual violence at the hands of police. Police brutality is really a misnomer because it suggests police violence is exceptional, but in Black and brown neighborhoods, police violence is the norm. During the slavery era, prison populations were composed almost exclusively of white people. When slavery was abolished, the demographics of prison shifted dramatically, virtually overnight. Take, for example, Alabama. Black people barely made up 2% of the prison population in 1850, before the end of the Civil War, before slavery was abolished. But by 1870, they were 74% of the prison population. Criminal punishment was the chief way the defeated South reinstated the white power regime and made free Blacks vulnerable to labor exploitation and disenfranchisement. Southern states targeted Black men, women, and children for imprisonment or apprenticeship by passing criminal laws known as Black codes, modeled after the slave codes. These prohibited Black people's freedom of movement, contract, and family life. They gave license to police to arrest and jail Black people for harmless conduct, like just being on the street without a good enough reason. Added to imprisonment was a practice of systematically forcing Black inmates to toil on chain gangs and leasing Black convicts as labor to planters and companies. By making free Black people criminals, white authorities could compel them to work against their will in a system that not only constituted slavery by another name, but was also so violent that it was worse than slavery, to quote the titles of 2 classic books about this practice. Between 1865 and 1880, every former Confederate state except Virginia established a system of leasing large numbers of Black prisoners to railroads, coal mines, and other industries that were rebuilding infrastructures devastated by the Civil War. Private lessees had complete custody and control of Black prisoners and were motivated to maximize their profits by extracting by force as much labor as they could, and had very little incentive to care about the welfare or lives of these prisoners because they could just get more from prisons. The result was rampant punishment, torture, and killing of prisoners with complete impunity. Leased prisoners were literally worked to death in the bowels of mines and their bodies dumped in mass graves. State exploitation of prison labor reinforced a gendered and sexualized form of white domination of Black women. Black women weren't protected by the Victorian norms of femininity, which shielded most white women from the degradation of prison and forced labor. Instead, Black women were actually frequently arrested for violating racialized gender norms by behavior deemed masculine, like quarreling in public. The wildly disparate treatment of white women and black women arrested for similar crimes is mind-boggling. For example, in Georgia, between 1908 and 1938, only 4 white women were ever sentenced to the chain gang, compared with almost 2,000 black women. So when we think about chain gangs, I tried to find an image with black women in it, I couldn't. But when we think about chain gangs, we think about male prisoners, but black women were often on chain gangs, working alongside men, and also forced to work as domestics in white people's homes. During the slavery and Jim Crow era, state agents meted out punishment to black people without regard to their guilt or innocence. In typical first-year criminal law class, which I've taught, we spend the whole first week studying the moral justifications for punishment. What makes offenders morally culpable and gives the state moral authority to punish them? And those themes cut throughout criminal law. But criminalizing black people entailed both defining crime so as to make their harmless, everyday activities legally punishable and punishing them regardless of their culpability for crime. The purpose of criminal punishment wasn't to give black people what they morally deserved, it was to keep them in their place. Today, criminal law enforcement still aims to control populations rather than judge individual guilt or innocence. Criminal courts are primarily in the business of managing marginalized communities rather than adjudicating their residents' culpability. Thousands and thousands of people living in targeted communities are routinely arrested for petty offenses or even for no offenses at all, locked up in jail without trial, and eventually released, sometimes years later. They're usually forced to plead guilty, whether they committed a crime or not, in order to escape their cells, and then they're saddled with court-imposed fees and monetary sanctions. Their jobs, families, and health irreparably damaged. And then they're arrested again and recycled again through this assembly line of predatory injustice over and over and over. Regulating black neighborhoods through this mass misdemeanor process far more characterizes our criminal justice system than the adjudication of violent offenses. This disconnect between social harm and carceral punishment is also evident in the immunity granted to police, prosecutors, and corporate executives who inflict sometimes even more serious harms, sometimes lethal harms on people. Prosecutors who have used unconstitutional methods to obtain wrongful convictions have not been criminally punished themselves. Few corporate executives who have been charged with crimes, they're rarely charged with crimes for actions that cost billions of dollars in losses during the financial crisis of 2008. Government officials responsible for devastating, deadly environmental injuries, such as lead-poisoned water in Flint, Michigan, typically escape criminal prosecution. So do we need prisons? Well, apparently not for the vast majority of social harms inflicted by wealthy and powerful people. Like prisons and police, capital punishment also has its roots in slavery. Enslaved people were subjected to gruesome executions for crimes that weren't punished by death if committed by white people. As longtime abolitionist professor Angela Davis argues, quote, "The institution of slavery served as a receptacle for those forms of punishment considered to be too uncivilized to be inflicted on white citizens within a democratic society." After slavery ended, lynching of black people became a grotesque feature of Southern society until almost 1940. Medieval forms of execution involving torture, burning, and mutilation sent the message that regular justice was too dignified for black offenders. The public torture of blacks accused of offending the racial order. And usually it wasn't the sexual racial order, although that was part of it. It was black people who were economically successful were lynched to deny them those opportunities of success. And that demonstrated whites' unlimited power and blacks' utter worthlessness. This nation's rights, liberties, and justice were meant for white people only. Black people meant nothing before the law. In the early 20th century, state-sanctioned lynching was replaced by state-sponsored capital punishment. Public hangings and electrocutions deliberately resembled lynchings. In the 1950s in Mississippi, crowds of white onlookers gathered at Southern courthouses to witness the electrocutions of black men in portable electric chairs that traveled from town to town. Last term, in the Bucklew case, a majority of justices were unmoved by evidence that Missouri's lethal injection protocol would inflict cruel and unusual punishment on a prisoner. They reasoned that, quote, the Eighth Amendment does not guarantee a painless death. Although Bucklew was white, the court's decision upheld lethal state violence that is disproportionately imposed on black men accused of killing white people. Like the torture rituals of lynching, the death penalty survives in modern America because it is a representation of white domination over black people. Tracing the function of today's carceral punishment system from the institution of slavery to its present-day subordination of black and other marginalized people suggests the system's repressive outcomes don't result from any systemic malfunction. To the contrary, the prison industrial complex works so effectively to contain and control these communities because that's precisely what it's designed to do. For that reason, reforms that correct problems perceived as mere aberrational flaws in the system won't work. They only help to legitimize and strengthen its operation. Reforming prisons results in building more prisons. That's why they have to be abolished. But prison abolition isn't just about tearing down systems. An essential aspect of prison abolitionist theory is that eliminating prisons must occur alongside creating a society that has no need for them. As prominent activist Mariam Kaba explains, it's the complete and utter dismantling of prisons, policing, and surveillance as they currently exist within our culture, and it's also the building up of new ways of relating with each other. Prisons will only cease to exist when social, economic, and political conditions eliminate the need for them. Of course, we can't abolish prisons today. But abolitionists are working toward a society where prisons are inconceivable. Many prison abolitionists see that work as continuing the unfinished struggle of antebellum activists to end slavery. So if today's prison abolitionists are the heirs to an anti-slavery movement that forged a radically different reading of the Constitution, might they adopt a similar abolition constitutionalism for the current carceral era? To answer this question, we need to explore the role of slavery abolitionists in conceiving of the drafting of the Reconstruction Amendments. First, it's important to understand how radical 19th century abolition constitutionalism was. The constitutional government of the United States was founded on the colonization of native tribes and the enslavement of Africans. It enshrined the power and freedom of a white male elite, along with their ability to restrict the power and freedom of everybody else. The framers made the exclusion of Africans and indigenous people from the democracy they established foundational to the US Constitution. Many of the nation's founders were enslavers themselves. As white property owners, they had a vested interest in preserving the fledgling capitalist economy fueled by captive labor and racist ideology. The original Constitution contained no provision that ended the slave trade, no provision that freed enslaved Africans or prevented future enslavement, no provision that protected Black people from all manner of degradation on account of their race. Although the word slavery appeared nowhere in the Constitution, several provisions directly enforced the institution. State and federal courts, including the Supreme Court, consistently ratified the slavery regime by interpreting key constitutional provisions and statutes in favor of slaveholders. As the court summed up in its 1857 Dred Scott versus Sanford decision, which denied an enslaved man his freedom, the framers intended to embed slavery into the Constitution because they believed that Black people, quote, had no rights which the white man was bound to respect. In short, slavery was constitutional. The 19th century movement to abolish slavery prominently included engaging with the Constitution. From the 1830s to the 1850s, abolitionists engaged in a heated debate over the Constitution's stance on slavery. On one side stood the Garrisonians, named after William Lloyd Garrison, who called the Constitution a covenant with death and an agreement with hell, because it permitted slavery. Well, when I shared a draft of my foreword with a prominent prison abolitionist, she said, "That's how I think of the U.S. Constitution still." I'm still trying to convince her there's another interpretation, which is, on the other side, there were anti-slavery constitutionalists like John Bingham, Lysander Spooner, and Theodore Dwight Weld, who read the Constitution instead as prohibiting or constraining the expansion of slavery. Now, an astounding aspect of this constitutional history is that many Black abolitionists grounded their radical approach to citizenship and freedom in the Constitution itself, even though it was a text that was written and interpreted to enslave them. The renowned author and orator Frederick Douglass, a formerly enslaved person himself, envisioned an abolitionist constitution even before slavery was abolished. Douglass struggled with whether the Constitution was a pro-slavery or anti-slavery document. He saw the Constitution's radical defect, as he called it, an internal contradiction that put the document at war with itself. Liberty and slavery, opposite as heaven and hell, are both in the Constitution, he wrote in April 1850. But by mid-1851, Douglass changed his mind. He parted with the Garrisonians and declared that he planned to promote the anti-slavery interpretation of the Constitution. He wrote in one of his autobiographies, quote, "If the declared purposes of an instrument are to govern the meaning of all its parts and details," this should be part of our statutory interpretation classes, right? "As they clearly should, the Constitution of our country is our warrant for the abolition of slavery in every state of the Union." To Douglass, basic constitutional principles were antagonistic to the existence of slavery, and the existence of slavery was antagonistic to the future of a democratic society. In 1865, after the Union won the Civil War, Congress enacted the 13th Amendment to the Constitution, prohibiting slavery and involuntary servitude except as punishment for crime throughout the nation. Slavery's defeat was met, though, immediately by a terrorist campaign to return newly freed Blacks to servitude and to reinstate white rule. President Abraham Lincoln's replacement, President Andrew Johnson, who was a white supremacist former slaveholder, rejected radical Republicans' vision of Reconstruction and supported the rights of Southern states. The radical Republicans responded to this crisis. They saw in the South that the Confederates were winning again and eviscerating the meaning of and power of the 13th Amendment. So they responded by passing the Civil Rights Act of 1866 over President Johnson's veto and enacting the 14th Amendment to the Constitution in 1868 to extend to the formerly enslaved as well as to any person born in the United States. Hear that, President Trump? Well, he knows it. That's why he wants to keep pregnant people from certain places from coming into the United States, because they'll become birthright citizens. That comes from the 14th Amendment. The language of the 14th Amendment can be traced to specific speeches and writings of leading anti-slavery advocates who developed an abolition constitutionalism in the preceding decades. The abolitionist constitution was forged as well by ordinary Black folks who abandoned plantations, took over ownership of some of them at first, served in the Union Army, and demanded the recognition of their equal citizenship. After the Reconstruction amendments were enacted, 4 million formerly enslaved people grabbed the short-lived opportunity to create their own economic, social, and political lives independent of white domination. But the Reconstruction Constitution was limited in numerous crucial ways. Although radical Republicans pushed to incorporate the abolition constitutionalism advanced by anti-slavery activists, they were forced to compromise with Democrats and accept more moderate versions of the amendments in order to achieve enough votes for enactment. No weakness in the Reconstruction amendments is reviled by prison abolitionists more than the 13th Amendment's exception for, quote, punishment for crime whereof the party shall have been duly convicted. Many prison abolitionists believe Congress deliberately added the crime exception to permit re-enslavement of freed Blacks by convicting them of crimes. As you may have seen the movie 13th by Ava DuVernay, which in some ways has that theme underlying it. As I described earlier, the re-enslavement did happen in the form of chain gangs and convict leasing. But Republican members of Congress vehemently opposed these practices as misuses of the punishment clause and violations of the 13th Amendment. The historical evidence suggests congressional Republicans left in the punishment clause, which was from earlier versions before the 13th Amendment was even passed, to permit continuation of the custom of sentencing people convicted of crimes to hard labor. And they didn't anticipate criminal punishment would become a mechanism of re-enslavement. Certainly, interpreting the clause today as license to convert slavery into imprisonment violates the aims of the 19th century abolitionists to free enslaved people. Yet activists like Frederick Douglass failed to achieve the ideals of freedom and democracy envisioned by the abolition constitutionalism they forged in anti-slavery struggle. So does that mean that abolition constitutionalism is futile? Well, I think it's important to remember that Douglass's reading of the Constitution didn't depend on its framers' intent. It didn't depend on the dominant interpretation of the Constitution, which, as I said, was in support of slavery. Abolition constitutionalism wasn't defeated by the 13th Amendment's punishment clause or by white supremacist terror. Instead, the anti-slavery movement used abolition constitutionalism as a tool to press its claims and a guide to envision the free and democratic society it struggled for the nation to become. Okay, I'm going to go a little faster than I thought I would, over the Supreme Court's anti-abolition constitutionalism. But I want to acknowledge that the US Supreme Court, after the Civil War, took the side of the Democrats instead of the side of the Republicans who drafted and were the primary enactors of the amendments. And that anti-abolition philosophy continues to this day in most of the decisions of the US Supreme Court. Three of the court's key anti-abolition doctrines are colorblindness, the discriminatory purpose requirement that you have to show, the smoking gun of blatant discrimination on the part of an individual government agent in order to prove discrimination, and fear of too much justice. And I get that term, fear of too much justice, from Brennan's dissent in McCleskey versus Kemp, where he said that the court did not overturn the death penalty because it feared too much justice. So despite the fact that there was airtight evidence of racism in the imposition of the death penalty, especially Black men convicted of killing white people are far more likely, the most likely people to be sentenced to death. The court refused to overturn the death penalty, and Justice Powell explicitly said, McCleskey's claim, taken to its logical conclusion, throws into serious question the principles that underlie our entire criminal justice system. Yes, they do. And he didn't want to overturn the entire criminal. So he and the majority upheld the death penalty. Flowers versus Mississippi is the Supreme Court's most recent application of the 14th Amendment to a criminal case. This was a case decided last June. Actually, as I was writing, and my research assistants were gathering information for the Harvard Forward, and the court overturned Flowers' conviction after he had been on death row for 22 years and had gone through 6 trials where the white prosecutor, Doug Evans, had relentlessly tried to put together an all-white jury by using peremptory challenges to strike every potential Black juror. And I call this an anti-abolition decision, despite its outcome. For Flowers, he has been, just in December, released finally from prison, but he can still be tried again, a 7th time, by an all-white jury, because the court did nothing to undo the mechanisms that led to his conviction in the first place. And the court emphasized how unusual and egregious this was, that it was the 6th trial in which they were considering this relentless discriminatory pattern by the prosecutor, and that they actually were breaking no new legal ground in finally, because of this blatant discrimination, overturning Flowers' conviction. Okay, so let me come to the last part of my talk, which is the potential for new abolition constitutionalism. Can we apply prison abolitionist theories to the Constitution's text, not only to condemn it, but also to use it instrumentally to achieve abolitionist objectives? And I take very seriously the question whether engaging with the Constitution can be helpful or harmful to a new abolitionist movement. I stayed up many nights tossing and turning and grappling with this tension. But as I said, I decided that there are good reasons for prison abolitionists to engage abolition constitutionalism and to see the Reconstruction Amendments as a compromise embodiment of the unfinished revolution that abolitionists continue to fight for. Now, Black Panther Party activist and author George Jackson, who wrote from prison, was a leading figure in the beginnings of a prison abolitionist movement, called for, quote, the gracious, sensitive, brainy types to hold the legal pigs to the strictest interpretation of the Constitution possible. Now, he certainly wasn't affirming the Constitution as a beacon for a radical movement. He did not expect judges to rule in favor of Black liberation, but he didn't throw out the Constitution. Instead, he was deploying it strategically as a legal, ideological, and rhetorical tactic to expose the hypocrisy of his imprisonment and the prison system's re-enslavement of Black people. I think his demand for the strictest interpretation of the Constitution possible could be seen as holding courts to the abolitionist reading of the Constitution envisioned by the anti-slavery activists who inspired the Reconstruction Amendments. And let me just quickly say that some of the ways that prison abolitionists can use the Constitution, they're actually already engaged in what they call non-reformist reforms. These are reforms that are aimed at eventually abolishing the entire system. They have to weaken rather than strengthen the state's capacity for violence and facilitate the goal of building a society without prisons. And some of those efforts are to stop prison expansion by opposing prison construction or shutting down prisons that already exist, ending police stop and frisk practices, eliminating the requirement of money bail to get out of jail, repealing harsh mandatory minimums, giving amnesty to individual prisoners, including political prisoners and prisoners who killed in self-defense, and decriminalizing drug use and possession and other nonviolent conduct. One of the prison abolitionists' major victories is the reparations ordinance passed by the Chicago City Council in May of 2015. That ordinance was a response to the reign of terror and torture I mentioned earlier in Chicago. And after decades of agitation, the activists won in the city council a package of measures which included not only monetary reparations, but also free tuition for survivors and their families, and an anti-racism program in Chicago public schools. Abolitionists can also use the Constitution to fight for non-reformist reforms that lessen the suffering of incarcerated and formerly incarcerated people, and also that build the blocks for a new society that doesn't rely on prisons to solve problems and meet human needs. In the process, prison abolitionists might imagine a new constitutionalism based on that society that they're working to create. I like to call it a freedom constitutionalism. In other words, this new constitutionalism wouldn't serve to sustain and improve the current US state and its carceral systems. It would serve to guide and govern a society in the making, one where prisons are obsolete. How that vision would be made real as a transformed interpretation of the constitutional text as it already exists, as an amendment to the Constitution, as Congress did in the 1800s after the Civil War, or as an entirely alternate charter of freedom. That's yet to be seen. So more than 150 years ago, an abolitionist vision animated a radical reconstruction of the US Constitution, what some have called the second founding of the nation. But the constitutional reconstruction never achieved the freedom anti-slavery activists intended. Today's prison abolition movement can reinvigorate abolition constitutionalism, and in turn, prison abolitionists' rethinking of constitutional meaning can further the unfinished struggle, the work we must do now to create a society that's more humane, free, and democratic. Thank you. Thank you.
Dorothy, thank you so much. That there's so much of interest and importance in that such a rich lecture, and I commend the article to all of you. I want to reiterate, Professor Roberts, thank you to the research assistants.
Yes.
More than 200 years of research on this.
It was all in one summer. All in one summer.
That's true. With this Harvard Law Review Forward, they give you only a few months to do it.
Yes.
So,
yes.
And there's so much to continue to talk about, and all of you in your writings and your work on this issue, and we're so proud, Professor Roberts, that you're here leading this. And the two of us are going to invite all of you up in a few minutes to join us over some food and drink in the Goat in Great Hall. But Professor Roberts has agreed to take a few questions. There's two mics that are kind of going to circulate. If you want to raise your hand, we can take a few minutes. I see one. We'll go first in the back there. And please, would you give your name when you ask the question?
Hey, Dr. Roberts. Oh, this is loud. Tara Khan from the School of Nursing. And you spoke to our class 2 years ago, and it kind of changed how I thought about a lot
Oh,
lot of things. So I
thank
really
you.
appreciate it.
I like to travel around the university. and the School of Nursing has been so welcoming to me.
It's changed the way that I actually teach some of our content about race in healthcare. Mm-hmm. And anyway, my question was, I really appreciate your lecture, and I my question is, so if prisons are abolished, so the obvious question is, what do we do with people that really need to, that are a danger to others?
That's a tough question, obviously. And the first question most people ask, I'm not surprised you asked it. So first, I would say that we have to remember, as I said in my talk, that we're not talking about tearing down all prisons today. So this is going to be a long incremental process where we reduce the numbers of people who are dangers to others through means that are not carceral. And so, number one, if we think about why people are dangerous to others, many of the crimes that are seen as dangerous, and of course, as I mentioned, the vast majority of people in jail cells today did not do anything that was really dangerous. The petty offenses. But if we're talking about violent crime, many people engage in violent crime because we live in a culture that supports violence. We live in a culture that supports gender violence, for example, violence against intimate partners. Certainly, there's lots that we can do to end the violence of people who are supposed to love each other. That should be something we can address through means, and people are doing it through means other than calling the police and putting them in jail, which we actually know doesn't work. So thinking about alternatives to lots of forms of violence it's not just what do we do with them if we don't have jails and prisons, it's that we might actually, I believe we would, be more effective at reducing that violence if we didn't rely on prisons and jails. So, do you see, we could just flip the question around. It's what's more effective than prisons and jails to ending violence. A lot of violence also comes out of the prisons themselves. where, as I pointed out, you have whole communities where the police are arresting people for petty offenses, and those people end up losing their jobs, losing their families, in poor health, with huge debt to the state, or sometimes private predatory companies that are in cahoots with the state, and they're desperate. They're desperate to survive. Or the war on drugs, where you have people who have health problems, who are locked up and their health problems made worse, and they're stuck. What are they supposed to do? They have an addiction, a substance, an illness that they're being punished for, and the only way they can get help often is to be subject to this brutal system. And so now, if they're going to stay out of the system, they have to resort to crime in order to medicate themselves. There's so many aspects of a carceral approach to human suffering that we could end, and that we would make our society less violent. I haven't even gotten to all the structural, institutionalized ways, besides the prisons themselves, but there are lots of other ways that force people into situations where they're desperate to survive. All the institutionalized ways that force people into segregated, poor neighborhoods without opportunities for earning a living, or the way in which our capitalist system forces people into jobs that aren't enough to survive on. If we change that, we would dramatically reduce the amount of violence in our society. So we have to work toward a society where we get rid of these institutionalized ways of dealing with human need by punishing people. And instead, if we had a society that was geared toward equal sharing of resources, or at least more equal sharing of resources. Like, I know you're not supposed to be a socialist nowadays, but it's a bad word. More equal. We have a long way to go between, socialism and what we have now. There's a big gap. And so that would substantially reduce violence, in addition to the cultural aspects, the way in which we have a society that glorifies violence, that is misogynist, that glorifies racial hatred, that polices people in violent ways and then says you shouldn't be violent yourself. So I hope you get a gist of where I'm going, because I could go on and on about all the ways that we produce violence in our society that is abetted by the criminal punishment system. And so to me, working toward, in tandem, reducing that punishment on the path to abolishing it altogether would reduce the violence and the danger that we're all afraid of. And let me just emphasize also a point I made about the fact that there are lots of wealthy, powerful people in America that are dangerous, that are threats. The threat to most of us is not somebody who's going to mug us. The threat to most of us is the environment we live in. And by that I mean the physical environment and climate change, but also the lack of access to good health care, the fact that we are in an unequal society is much more of a threat to our health. Most people aren't going to die, from someone killing them. And those who are, as I said, we could find ways to prevent that as well. We're at the threats to most of us, especially the most marginalized people, who are the ones who are most likely to be locked up. It's structural. And the people who are causing that don't go to jail. So, we don't think they need to go to prison. So clearly we don't think that social harms have to be addressed by prison. Do you see what I'm saying? Okay, I'm going to end there to allow for another question. Sorry. I have a bad tendency of giving a second lecture. I'm going to try not to. Try not to.
Let's get a couple more questions.
Oh, boy.
How about yes, gentleman down there?
Thank you, Doctor. I'm Jasper Jones Bell. You know me. I'm representing an alumnus of the school, and I'm also a representative of the local tribal government. You really need to go back to 1492 rather than 1609, because in 1492, there were no prisons in this country, and the actual currency was not gold, oil, drugs, and diamonds, which is really the problem that's driving this. And the crimes in the suites that you were hitting on is what's driving the crime in the streets. So what we need is actually an analysis, which was done in the 1980s, which discovered that every time you allow someone to end up in prison, you knock off about $2 million of the wealth of society. So you really need to restructure all your institutions. And I encourage you to go back and look at 1492 and incorporate that.
Yes, I agree with that. And I did mention that the Constitution was founded in the conquest and subjugation and exclusion of indigenous people. I think that is very important, because that did even predate the importation of enslaved African people. And I think it's important to think about the founding of the nation in settler colonialism and in the enslavement of human beings. I absolutely agree. I focused this lecture on slavery in particular because I wanted to make this argument about how the anti-slavery amendments could be used in a continuation of the fight against modern forms of slavery. But abolitionist thinking is more capacious than that. I was trying to make a logical link together, hopefully coherent argument. But it's more capacious than that, and it can take into account as well the dispossession of Native peoples. So I agree with your point that we need to include in our ideas about the way the Constitution was founded and continues to operate, the dispossession of Native tribes as well as the enslavement of Africans. And let me just say one more quick thing about that, which is that you mentioned that when the settlers came, European settlers came to America, there were no prisons, which reminds me that we can think about alternatives that groups that haven't been in power and haven't been able to dominate the way we address needs and problems have been able to address needs and problems in less violent ways. And so we should be open to different cultural approaches. As I mentioned, I think this is partly a cultural as well as a structural movement to create a new society where we don't need prisons.
One last question here. Yeah.
Hi, good evening, Professor Roberts.
Hi.
I'm curious if you can talk more about how we can figure in our contemporary immigration system.
Yes.
In the movement for new abolition constitutionalism, specifically for Black and Brown people who are subjugated to both the criminal justice system as well as the immigration system.
Yes. So again, I focused on the prison system, and police and capital punishment. I decided to focus on those three areas, those aspects of the carceral system. But I did mention that it extends beyond prisons. It extends to just about every institution in our society, including institutions that are supposed to help people. And so in my own work, I have focused a lot on the foster care system. And in fact, I'm my next book project is going to be on the foster care system, and which is entangled with immigration, because with, for example, the separation of families at the border, I think many Americans began to see that immigration policy could be very violent as well. And so immigration policy is part of the carceral system. It's an approach, just like prisons, just like foster care, just like arresting children in school, that uses punishment and detention as a way of dealing with human needs and social problems. It fits that definition perfectly. It looks at people who are coming to the United States, often fleeing violence in their homeland, and instead of figuring out a humane and equitable and just way of integrating them into our society, the response is a violent, detention-oriented, deportation-oriented, arrest-oriented, incarceration-oriented. All those things happen in our immigration policy. And so definitely immigration, foster care. I would also include the campaign now, which tomorrow is going to be before the U.S. Supreme Court again, to force pregnant people to be controlled by the state and not have control over their own reproductive lives. That, to me, is a carceral project. Many of the women who don't comply with these norms of reproduction end up being locked up in prison. You know, I mentioned my work on prosecuting Black women who use drugs during pregnancy. That is a carceral approach to pregnancy. So if we think about it, again, there's so many aspects of U.S. society that fall under this carceral approach, and immigration is definitely one of them. And many prison abolitionists include opposition to deportation and a carceral approach to immigration as part of a broader abolition movement.
Well, I know we all have more questions. There are more lectures to come and more articles to come. And we're glad that you're here. Lots of research and continued work for all of us.
Oh, yes. Put out the call already.
But now is the time to in a moment, move upstairs, and just please, all of you, join me and thank Professor Roberts for this.
Thank you.